Montana's corner crossing debate is one of the most fascinating public access legal issues or battles in the West, and certainly in Montana. So for those unfamiliar, what corner crossing is it occurs when someone moves from one parcel of land, say right here is public land, onto another parcel. Let's pretend that this corner is public land, but that these two sections are private land. So it occurs when someone moves from one parcel of public land onto another parcel of public land without touching physically either portion of the private land or damaging it. And in Montana and across much of the West, there's checkerboard landscape. And there's lots of instances where two pieces of public land meet, but are kind of boxed in by pieces of private land. In Montana alone, it's estimated that there's over 870,000 acres of corner lot public land in Montana that currently private landowners get exclusive right and enjoyment of. So the legal landscape shifted pretty dramatically relatively recently when the 10th Circuit Court of Appeals came out with its decision, Iron Bar Holdings v. Cape. And in that case, 4 hunters crossed between public parcels at a common corner without physically touching private property. And the court held that under the facts presented, the landowner could not use federal law to prevent access and that the hunters did not violate federal law. So that ruling applies in the 10th Circuit, which is where Wyoming is. Montana's in the 9th Circuit, so that decision is not necessarily controlling in Montana. However, the controversy intensified after Lieutenant Governor Juris publicly argued that corner crossing is illegal under Montana law, a position that drew criticism from public land advocates who argue that the law remains unsettled and requires either legislative clarification or a court decision on the matter. Critics have also questioned whether elected officials like Lieutenant Governor Juris, with family ties to large ranching operations, should play a leading role in shaping policy on corner crossing. After all, these elected officials represent the citizens of Montana, not the family holdings. So public land advocates have argued that transparency regarding these potential conflict of interest are important whenever public access and private land ownership rights conflict. So at Murphy Law Firm, our view is pretty straightforward. Montana should adopt a clear legal framework for responsible corner crossing when no private land is physically entered or damaged. And public land, belongs to the public. So there should be some public use and enjoyment for all acreage of public land, including the 870,000 that are currently landlocked by private land. And those principles, public land belongs to the public, but private property rights deserve respect and protection. Those two principles are not mutually exclusive. A carefully crafted law can protect landowners' rights while ensuring that hundreds of thousands, almost 1 million acres of public land are not effectively locked away from the people who own it, which is the citizens of Montana. So the corner crossing debate is ultimately about balancing two core and very important Western values, Montana values: strong private property ownership rights and meaningful public access to all public lands in Montana.